Okay, let's dive right into this. Welcome to this explainer on what is truly a landmark case from the Constitutional Court of South Africa. Today, we're unpacking the absolutely fascinating and honestly highly complex case of Garreth Prince. We are going to look at exactly what happens when the rigid, black and white structure of the law collides head-on with someone's deeply held religious convictions. It's the kind of case that really forces us to ask some profound questions about freedom, government regulation, and how a society accommodates its minority groups. So, here is the core conflict to get us started. Picture this. You are standing right on the threshold of your absolute dream career. You've done all the grueling work, you've passed the exams, but there's just one final hurdle left. Now imagine that crossing that hurdle requires you to completely abandon your sincerely held religious beliefs. This was the exact dilemma facing Garreth Prince. He was forced to choose between becoming a lawyer and staying true to his faith. And that sets up a fundamental question for us. Can a future lawyer openly declare his intent to break the law? Section 1. An attorney's dilemma. Let's take a quick look at where this all began. Now, Garreth Prince was undeniably prepared for the legal profession. He satisfied every single academic requirement, securing both his B.Juris and LLB degrees. He was totally ready to register his contract for community service with the Law Society of the Cape of Good Hope. But Prince is also a devout Rastafari. In his application, he was completely upfront and honestly disclosed 2 previous convictions for the possession of cannabis, and even more significantly, he stated that because of his religion, he had every intention to continue using cannabis in the future. Well, as you might expect, the Law Society drew a very hard line here, completely refusing to register his contract of community service. Their stance was pretty clear-cut. A person who actively declares their intention to consistently break the law is simply not a fit and proper person to be admitted as an attorney. From their perspective, allowing someone to practice law while openly defying a statute would bring the entire attorney's profession into disrepute. Section 2. The holy herb. You kind of have to wonder, why would someone risk their entire career over this? To really understand this case, we have to understand the deep sincerity of these beliefs. Rastafari is a constitutionally protected religion, and it originated over 70 years ago as a black consciousness movement. In South Africa, there are about 12,000 adherents. It's a decentralized religion, but it heavily promotes universal values like peace, equality, and justice. Followers abide by strict moral codes like the Nazarene Code, and they gather for sacred religious ceremonies, such as the Nyabingi. And this brilliantly illustrates the real crux of Prince's argument. To the Rastafari, cannabis, or ganja, is absolutely not a recreational substance. It's considered a sacred, God-given plant that's basically essential for opening one's mind, gaining divine wisdom, and communicating with the Creator. This is a massive distinction. The use of the herb is a literal act of prayer for them, not just an opportunity for casual intoxication. In fact, the religious use of cannabis within the faith is incredibly diverse and governed by really strict protocols. Sure, it might be smoked individually in a spliff or communally in a water pipe known as a chalice, which serves as a form of Holy Communion. But it goes way beyond smoking. It's burnt as incense on altars, it's eaten in food, drank as a tonic, and remarkably, they even bathe in it. For the Rastafari, the body is a temple, and cannabis is used to physically and spiritually cleanse it. Section 3. The state's defense. Now, the government, of course, has its own mandate to uphold. Let's look neutrally at the medical reality that experts on both sides actually agreed upon during the trial. So, cannabis is a psychoactive hallucinogen containing THC. The harm it causes is cumulative and dose-related. Experts agreed that while prolonged heavy use certainly causes harm, a low dose, something like a few joints, doesn't actually cause physical harm. So the real medical danger lies in uncontrolled high-dose abuse, rather than minimal or ceremonial use. But, the state has a very legitimate interest here, too. The Drugs Act and the Medicines Act explicitly list cannabis as an undesirable, dependence-producing substance. The state's mandate is to suppress illicit drug use, which they argue is a highly pressing social purpose. Plus, the government is bound by international treaty obligations, like the Single Convention on Narcotic Drugs. Fighting the war on drugs is a major priority for the state in order to protect the general public. Now, you might be thinking, well, why not just give the Rastafari a religious exemption? Well, Senior Superintendent Mason testified about the massive logistical nightmare this would create for the police force. First off, how do authorities identify a bona fide Rastafari out of a loosely associated group of 12,000 people? Second, they'd have to develop completely forged proof permits, possibly even taking fingerprints.
Third, it would require establishing a dedicated national database and hiring dedicated personnel to administer the whole shebang. The state argued this was practically impossible to police.
Let's move to Section 4, weighing constitutional rights, and see how this all builds up. This brings us to the central constitutional friction of this explainer. On one hand, we have Sections 15 and 31 of the South African Constitution, clearly guaranteeing freedom of religion and the right for communities to practice their religion. But pushing right back against that, we have Section 36, the Limitations Clause. This states that rights can be limited by laws of general application, provided that the limitation is reasonable and justifiable in an open and democratic society. So the court somehow had to weigh these competing interests against each other. The concept of human dignity is absolutely crucial here. Criminalizing a religion's central sacrament forces believers into a terrible corner. The right to believe and to actively act on those beliefs is a key ingredient of any person's dignity. By making literally zero distinction between a devout Rastafari and a recreational drug abuser, the law effectively labels an entire religious community as criminals, which degrades their inherent dignity.
Section 5, the split decision. Let's see how the Constitutional Court ultimately ruled.
The court was actually deeply divided on this, and we need to look objectively at both conclusions. Justice Ngcobo wrote a really compelling minority opinion, arguing that the total ban on cannabis was simply overbroad. I mean, it surprisingly caught completely harmless uses in its net, like burning it as incense or bathing in it. He pointed out that the government already grants strict exemptions for medical and research uses. So, he reasoned, the government could definitely use less restrictive means and strictly regulate a religious exemption, rather than slapping down a blanket ban that infringes on constitutional rights. So, the crucial point is where the majority landed. The majority opinion, delivered by Chief Justice Chaskelson, along with Justices Ackerman and Kriegler, took a different path entirely. They acknowledged that Rastafari is a vulnerable, marginalized group, for sure. However, they concluded that criminal laws must apply equally to all citizens across the board. They found that carving out a religious exemption for this specific drug would be virtually impossible for the state to manage and enforce. Ultimately, they ruled that the general ban on cannabis is a necessary, justifiable limitation to protect the broader public from drug abuse. And that leaves us with a truly profound question to end on. Where exactly do we draw the line between individual conscience and general law? The Garreth Prince case shows us that in any democracy, the balance between protecting minority freedoms and ensuring collective security is incredibly delicate. Sometimes the absolute nature of the law leaves absolutely no room for personal conviction, no matter how sincere it is. I want you to act as a jury in your own mind for a second. If you were sitting on that court, how would you balance the right to practice one's faith against the state's duty to police its society? Thanks for joining me on this explainer, and keep questioning the balance of the world around you.